Welcome you all to the lecture series on corporate law. The present discussion would be on the new concepts introduced by the Companies Act 2013 by the name class action suits. It also has another names in various other countries, in particular to the United States of America and also the other countries, what we call it as class action suits, Mareva Injunctions, and the freezing orders. This provision and this concept has been introduced in the Act in addition to the provisions which are available to the minority shareholders in the case of the oppression and mismanagement. In one of the previous lectures, which I will be providing the link, we have discussed about the prevention of oppression and mismanagement. In the same chapter, under the provisions of Companies Act, the class 245, section 245 talks about the class action suits. Now let us discuss, let us understand why this particular provision was introduced, how far this particular provision has become successful in today's context, the meaning thereby. We read in everyday newspapers the freezing orders of the bank accounts and the freezing orders of the particular enforcement agencies. Now let us see the meanings of the class actions. If you see the meaning of the class action suit, the class action means as a class action lawsuit or class suit or representative action is a type of lawsuit where one of the parties is a group of the people who are represented collectively by a member or members of the group. The class action originated in the United States and is predominantly a US phenomenon, and also in Canada, as well as several European countries with civil law. Now here I will try to explain. India basically, as we follow the common law principles, the concept which is well versed in the United States of America as well as in the European countries and also the civil law countries that we have adopted in our Companies Act in 2013, and has also made lot of changes in the various claims, particularly in law of torts as well as law of contracts, or wherever you want to find or wherever you want to file a case on a group actions, on a action which is required to be taken by the wrongs done by the corporates, the wrongs done by the multinational corporations, either by the tortious liability, either for the oppression and other provisions. This provision has been introduced. And the introduction of these, when you see, the class action is also called different names, as I already told. It is called as the class action suit, representative action, as well as a concept which is prevalent under the civil law countries. Now let us see the other name for this. Mareva Injunctions. Mareva Injunction is a name used for the freezing of asset or a protection order type. It's called as the injunctions, which prevents the defendant or the respondent from dealing the whole or part of their assets by moving assets abroad or dissipating them while in legal proceedings and are ongoing. It's a simple concept. if A filed a case on B and B tries to transfer or move the assets of the company, and A can claim through the court asking the B to stop, otherwise called freeze. As we all know, freeze means just stop it or hold it. So completely freeze means the court can pass an order, you don't do any activities, you just hold on. So, and also they can pass an order called as the Restraining Orders. Majority law students may have the doubts. Sir, this provision is already existing in the Civil Procedure Code, which we talk about the temporary injunctions and permanent injunctions. Then what is the new which we are going to deal in the Companies Act? Let me repeat again. In Civil Procedure Code as well as in the company law, we find very frequently these provisions. Getting of an injunction order, asking the defendant not to do any act, asking the defendant to restrain something is already an existing provision in the Indian law. And suddenly what is the new thing that brought into the Companies Act through 2013 Act? Now, this is a provision which I will try to explain and discuss maybe another some point of another 10-15 minutes. Now kindly remember, section 245 of the Companies Act talks with a terminology called class action suits, right? Section 245 of the company law is the clause of procedural clause as well as substantive clause, right? This provision has given a right, right? This provision has given a right to certain people to file a case for different remedies. Who can file the case, right? The question will come, who can file the case? Number 1, member. Number 2, members. Number 3, depositor. Number 4, depositors. Number 5, any class of them. Now suddenly you will have a doubt. What is this numbers, sir? Let us try to understand why this particular classification is given. Member, members, depositor, depositories, or any class of them. As already we discussed various classes which are available in my previous links. The member is being defined in company law. In a simple term which we understand, a member means a shareholder of a company. Say for example, if there is a one member who cannot file a case against a company under oppression mismanagement, then he is being provided a right under the section 245 if he fulfills the conditions laid down under the section 245. I will again repeat. The section 241 to 244, section 241 to 244 deals about the prevention of oppression mismanagement, where the minority shareholders are given a right when the activities of the companies are conducted in a prejudicial manner in the interest of the company, they can file a petition under the tribunal. So kindly remember, this provision is already there, or this context is already explained under the section 241 to 244, which talks about right given to the member of the company when you have the members 1/10 of the capital, etc. and all. In addition to the provisions, right? In addition to the provision of the oppression mismanagement, Section 245 was introduced. Let me take back to the historical background. Why the Indian Companies Act or the drafters of Indian Company Law are supposed to introduce this provision called as a class action suit. This class action suit came into existence by looking into the various scams, like for example Satyam scam and also the Sarada scam or Arshad Mehta scam. There are various corporate frauds and scams which are happening. In order to file for the remedy under these particular corporate frauds or the corporate deceits, the members or the depositors or any one of them should be provided a remedy. And the question will come, under 244, under the oppression mismanagement, you require certain minimum number of members, etc. and all. And the class action suit gives a right not only to the violations or not only to the actions arising out of the tortious liability, and it also gives a right the obligations arising out of breach of the contractual obligations. I will repeat again. Class action suit can be raised not only just because of the tortious liabilities, that means a breach of an obligation without a contract, and secondly, breach of an obligation through the contract. So therefore, it has given the wider powers which are existing under the US jurisdiction as well as UK jurisdictions and European Union jurisdictions. So who can file the petition? Member, members, depositor, depositories, and any class of them. When they file a case before the tribunal, that is NCLT, what are the orders that NCLT can pass it? The ground to file a case, or the cause of action to file a case is that if the affairs of the company are being conducted in a manner prejudicial to the interest of the company or prejudicial to the interest of the members or the depositories. If the activities of the companies are something which are against the interest of the members or to the depositories, then they have the right. I will repeat again. The similar language is there under the previous provisions, but don't get confused. It is a new concept which is introduced in the Indian legal regime, though it was prevailing under the law of torts and other tortious actions. But under the Companies Act, this provision is again being introduced. So once the petition is filed before the tribunal, what type of remedies that the tribunal can pass? Number one, to restrain the company from committing an act which is ultra vires of articles and memorandum. That means if there is an act conducted by the company beyond the powers of the MOA and AOA, then court can pass an order, stop your activities. That's the first one. Second one, if any of the provisions of MOA and AOA are violated, right? Again, you can pass an order called Restraining Orders. This is what we use the terminology called Restraining Orders. If any company which acts ultra vires, if any company which violates the provisions of MOA on the articles, then you can ask for an order that is called the restrained provisions. Let me give a simple example to understand what can be an ultra vires activities. Say for example, there is X Limited Company incorporated for manufacturing of, say for example, mobile phones, right? Instead of manufacturing the mobile phones, this X Limited company is manufacturing, say for example, of cars. The object is manufacturing of mobiles, but doing the business in manufacturing of the car or doing about the cars. So this directly comes a contradiction between the provisions, which is the purpose for which you are incorporated one, but you are doing the power or you are doing an activity which is not permitted by the MOA. So in a simple understanding, if the act is beyond, right? If the act is beyond the powers of the, here is, so if the act is beyond the powers which are there in the articles of association, then automatically you have the powers. That is number 1 and number 2. Number 3 is to declare a resolution of alteration of MOA and AOA void if the resolution is a suppression of material facts obtained by the misstatements of the depositories. That is called as, if the company has done something which is called as the misleading. Number 4, again to restrain, directors acting on resolution. Restrain a company for doing an act contrary to the provisions of Companies Act or any other law for the time being in force. Now this is which is required, very important. If the company is doing any activity contrary to the provisions of any law in India, if the company is doing some wrong under Indian Penal Code, if the company is doing some wrong on environmental law pollutions, a violation of environmental laws, if the company is doing some activity not implementing a CSR, if the company is doing some activity which is not permitted by the law, then you have a right under section 245. Kindly remember this one. So section 245 has given a very wider powers in the name of the class action suits to file the case before a tribunal. That's why they said the restraining orders. If you again recapitulate, number 1 restrainant, number 2 restrainant, number 3 restrainant, number 4 restrain. So you are almost all getting 4 to 5 restrainant orders where the tribunal can pass asking the company not to do an activity against to the articles of association, against to the MOA, contrary to the Companies Act, and contrary to the any provisions of the laws. So therefore this is where it comes about the restrainant orders. And again, in addition to this, it can also restrain any actions contrary to the passed by the members. It can also file, a case can be filed to claim damages and compensation or demand or any action from it. Now let me explain for the people who are listening these lectures of law students. The damages means in law subject arising through the tort. Tort means a civil wrong. Civil wrong means not predetermined, right? Not predetermined claims or not predetermined contract. I will give a simple example. Sir, what can be an example for the damages? That is called, like you can see, a Bhopal gas tragedy case, right? If there is an accident, if there is unforeseeable activity which happens in a corporations, and but particular point of the time, we don't know who are the affected parties, how much damage that they have to pay. Damage generally comes from predetermined contract. That means A enters into a contract with the B. In the case of the failure to enforce the contract, and B has to pay the money to the A, it is called as a damage. When you look about the damages, here the parties are not aware. The quantum of damage is not aware. So in case of the environmental damages, in the case of the mass torts, so it can be divided. Then therefore, the parties can file a case. This is what we call as the claim damages, compensation and demand. Kindly remember, every terminology has a legal meaning. What are those terminologies? One is the damages, second one is the compensation, number 3, demand of any suitable action. This is again given a scope to the law to interpret by tribunals. Point number I, in further moving on that, it can also say the company and its directors for a fraudulent or unlawful act, and they should become liable. And also they make a liable, right? Who are liable? Action against director and the company, and also the auditor, including auditing firm. This is the best example of Satyam's case. All of you may be knowing the famous Satyam scam, where one of the law firm, that's called PricewaterhouseCoopers, PwC. Auditor and auditing firm will be also being liable if the auditor or auditing firm provides the wrongful statements and unlawful. And the new important, very, very important term which is introduced in this particular provision is that expert, advisor and consultant. Prior to the 2013 Act, there are a lot of people who are associated with the company providing the opinions in the name of the expert, in the name of the advisor, in the name of the consultant. And these people who provide the advice to the company, wrongful advisors, under the category of an advisor and consultant, and they used to tell that we are not liable because we give some opinion. On the opinion of a consultant or advisor, if the company tries to do some misuse or does some wrongful act, in that case, the expert becomes liable. I will repeat again, the new introductory provision under the Companies Act, the expert, advisor and the consultant, these people are liable if they provide any misleading statement and also if they get unlawful gain. So the liability part under 245 is that director of the company and the company, auditors, expert, advisor and the consultant, these people becomes liable if they provide the wrongful opinions and acts also wrongfully. And thereafter the particular other provisions are there where the members or depositors demands for the suitable actions, again auditor firms, liability will involve on all the firm and the members. Actually we require to study some important cases. Generally what happens, if we talk about the chartered accountants, the auditors, who provides the legal opinion or who provides the accounting opinions, they always try to escape and state that we are not liable. And the auditors who does manipulation of audit reports, this we call it in the corporate law, that is called systematic, right? Systematic accounting fraud. This is very famous in corporate law frauds. The people who have highly qualified, the people who have highly knowledge, and some of the people who are highly qualified who are not having the professional ethics involving in the corporate frauds and doing an activity to defraud the investors and to defraud the the members and also collapse the stock markets. These people need to be punished. In order to punish these people, the New Companies Act, now it can be old, now it's almost all, we are completing a decade of Companies Act. And after a decade of Companies Act also, the cases are being filed, but as we all know, where the courts are being overburdened, the process or the judicial process is taking the huge amount of the time. Now, how many people can file? This is a debated issue. Now, the requisite number they says, if the not less than to be 100 depositories, that means out of the depositories should have the total number of depositories 100. And sometimes you can also involvement of the one member also. Because in some of the frauds, even a single member can file a case before the tribunal where the cause of action is going to attract the rights of the depositor or well as the members. Because there is a lot of debate on this, whether you require a proper number like under oppression mismanagement, though we have the prescribed number. However, the approach of the judiciary, approach of the tribunals are that even a single person can file a case, single person in the sense a single member or the single depositor may file a case on showing of an evidence, on showing of the proof that the activities of the company are conducted prejudicial to the interest of the company, prejudicial to the interest of the members, prejudicial to the interest of the depositories, then the court can take up the case. Because basically, this concept came into existence in the United States of America, where there were no remedies available under the existing law. Then the corporations as well as the wrongdoers used to evade the liability under the law, used to escape from the clutches of the law. Therefore, in 2012, after looking the various scams, after looking about the Indian capital market structures, after looking into the scams or awareness of the investor education, this provision has been introduced to educate, to bring the knowledge among the investors as the members, and also keep an eye on the people who are giving the wrong advices, on the people who are giving the wrong advices and getting the wrong or unlawful gain, that they should be punished. The motto of the class 245 is that if there is a person who conducts an act and gets the wrongful notice, then there will be the class action suits. And these class action suits can be filed anywhere in the world. Even if the cause of action arises in the US or European Union, you can file a case in India. If there is a cross-country actions are there, there is also a provision which you can have the lead applicant as well as following the other applicant. These cases will happen about where there is a large number of victims. Victims, I am using the terminology when the investors become as a victim. I am using a terminology when the investor becomes the victim, right? investor becoming as a victim. Investors invest the money in a company in order to get the returns by virtue of dividends or by virtue of interest. And when the investor has been cheated, defraud has become, then this becomes as a victim. So what investor has to do? So where this investor will go and file a case. So therefore they brought this provision to protect the interest of the depositories, to protect the interest of the investors, where the remedy can be provided through the clause 245. That's called the section 245 of the Companies Act, provides the justice called what we can call as the investor victim justice. Generally we read in criminal law the victim justice, whereas in the corporate law we have the concept called investor victim justice, which we can propound, which we can say that yes, it can be propounded and there will be advantage on that. And this is what I try to briefly explain to you under section 245. In the next classes, I will be taking a case-wise analysis as and when required, how far the section 245 has been implemented, who are the beneficiaries, and etc. and all. So kindly listen and put your questions or any of the points which you are unable to understand in the chat box. We will try to discuss in the later part of the time. And remember, section 245 of the Companies Act, which we call as the class action suit, is an innovative provision, is a new concept to the Indian legal system, which has been implementing and where people are required more and more awareness. So thank you. We will see in the another lecture.